a sense of community when you're free. Rolling through the mountains, rolling through the valley, rolling through paradise with me.
Hello, everyone. Welcome to the show. Well, my guest has been on here a few times before, but it has been quite a while. So I'm really pleased to welcome back Aatif Nanji.
Hi, Nancy.
Hi, did I get it right?
You did. Thank you.
Okay, so for those of you who don't know, Aatif is a notary public with Simpson here in Chilliwack. So it's nice to see you again.
You too. Thank you.
So some of the things I want to know is like when is it okay to get a notary as opposed to, say, a lawyer?
With regards to depending on what type of legal situation or what your needs are, if it's just if it's a will, like estate planning type of thing. So if you just need a basic will, a notary is probably fine. Where a lawyer would be needed is if you have very complex assets, like let's say if you have maybe a large corporation or maybe a couple of corporations with some complicated structure. That would be a good reason to use a lawyer instead of a notary. However, if you have a small business and you just want everything to go to your wife or your kids when you pass away, that may not be necessary. You might still be able to use a notary. Another really good reason to use a lawyer instead of a notary is if you need to set up a trust for someone over the age of 19. So notaries can set up trusts for kids, but they have to expire when they turn the age of majority. But if you have a situation where, let's say, you don't want your children to get the money when they turn 19, which not a bad idea, given the responsible kids are, or if you have a disabled or a child that's going to be on disability benefits, or if that would be another very good reason to use a lawyer, because they can set up a trust for that adult child so that the inheritance won't interfere with their disability benefits. Because if somebody's on disability benefits, they get a big chunk of money at one time, it can mess with their entitlement. So in those situations, we recommend they use a lawyer. Or if another, less common, but still, not unusual situation is if you have a child, let's say substance abuse issues, and you don't want them to have the money right away, or you want the money to be held by somebody else for their benefit, then you can use a lawyer and set up a trust for them. But for 90%, for 90% or more people that just need a basic will, probably using a notary is going to be sufficient.
Right. Now, how important is it to have a will?
I would say pretty important. If you die without a will, there are laws that determine what happens to your estate when you pass away. So they're called the laws of intestacy. So if you're, for example, if you're married with children, what happens that if you pass away is so $300,000 goes to your spouse, and the balance, whatever's left over, gets split between your spouse and your kids. Now that's assuming that your kids are common to you and your spouse. If you have children from a different prior relationship or a different marriage, then your spouse's share gets reduced to $150,000, and then the balance is split between your kids and your spouse. So for many people, that's not what they want. They would probably want everything to go to their spouse first, and then if both of them are gone, to be split between the kids. So that's where it will be important. Also, just being able to choose your executors, choose your guardians for your children. I think that's really important. And then also makes things easier for the people dealing with your estate. If they have a will in hand, a lot of places that they need to deal with, whether it's banks or insurance companies or, anywhere where they have to wind up your assets or your accounts. A lot of these places, they want to see a will, and showing them a will with the executor's name on there is going to make the executor's job a lot easier.
So what if you don't have a will? What happens in that case?
So if you don't have a will, it's called dying intestate, and those laws of intestacy take hold. So if you're married with children, it does that split I talked about earlier. If you are married and have no children, everything goes to your spouse. If you have no spouse but you have children, everything gets split equally among your children. So their distribution schemes are not too bad, but somebody will then have to apply to administrate the estate, which is similar to being an executor, but it's just a few more hoops to jump through a little bit. The paperwork's a little bit different. Generally, it's considered easier if there is a will in place for someone to deal with the estate.
Right. Now, let's just say you die, but you have very little, you have a will, and you pass away and you have very little, like maybe you have 20,000 in your savings or your assets, Do you have to go through probate?
That's a very good question. So actually, based on your example, the answer would be no, or most likely no. So generally speaking, if the estate is worth less than $25,000,
Mhm.
probate is not always required. There are exceptions to the rule. Like some places may insist on a grant of probate before they'll release the money to the administrator or the executor of the estate. Sometimes, or if you, example, if you have a piece of property, even if it's worth $5,000,
Right.
like a little piece of land somewhere, you won't be able to get that transfer to your beneficiaries until your executor or administrator gets that grant of probate or grant of administration from the court. So $25,000 is kind of the general threshold, but
Right.
there are exceptions to that rule.
Okay. Now, another thing when you use a notary is, let's just say I'm becoming to the age where I'm like, I'll have to have somebody assigned to take care of my finances if I'm no longer able to do so, right? So I'll get my daughter to do that. Do you go to a notary for that?
Yeah, so I think you're talking about power of attorney, which is
Yes.
something, yeah, we do a lot of those here.
Okay.
Yeah, I don't think you need to go to a lawyer again unless you have something very specific or complicated in mind in terms of divvying up powers. Maybe you want to divide up the powers over your assets between different people.
Mhm.
Maybe this is for people that have, again, a very large like maybe very large net worth with corporate structures and things like that. Maybe they don't want one person looking after everything. But for most people, they're going to want they to appoint one or two people to manage their affairs, maybe their spouse or their kids, or maybe a combination of them. And that's and I wouldn't say you need to go to a lawyer for that. You can get that done with a notary.
What about a living will?
Living wills are living wills are in BC what we refer to as a living will could refer to two different documents. So there's one called a representation agreement and another called an advance directive. An advance directive is probably the most similar to a living will. That's basically a statement that you write up, a personal statement about your wishes, where you say these are the treatments I would want or not want if I'm not able to speak for myself. So it's a direct communication to you from you to your healthcare provider. So that's what we call an advance directive in BC. Alternatively, you could do something called a representation agreement. It's very similar to a power of attorney, where you're appointed, where instead of stating what you want, instead you're appointing somebody else to make the decisions for you if you can't speak for yourself. So in a representation agreement, you say, this is my representative. If I'm not able to speak for myself, this person gets to make all decisions about my health and personal care, whether it's, medications, treatments, if you have to go into long-term care, what facility you go to, things like that.
What about your finances? Do they, like if you have a bank, obviously, you would have a bank account or something. So would they be able to make those decisions too?
Not with a Section 9 representation agreement. So if somebody has full capacity, the expectation is that they're going to do a power of attorney for management of their finances and a representation agreement for management of their healthcare.
Oh,
If a person has reduced or diminished capacity, let's say they've already suffered a stroke,
yeah.
or maybe they have some other kind of mental health issues with that, where they don't have the capacity required to do a power of attorney. There is an alternative document called a Section 7 representation agreement. It's specifically designed for people with diminished capacity, and in that incorporates both healthcare decisions and financial decisions. However, they're more limited in scope than you would find in a Section 9 representation agreement and a power of attorney.
So you can get that done through a notary?
Yeah, we do those too. Yeah,
No.
we don't we only use those as a last resort if someone is not meeting the capacity requirements. So capacity requirements is maybe something else. If you don't mind, I'll just speak a little bit about, because a lot of people don't realize that to do these documents, whether it's a will, power of attorney, or a Section 9 rep agreement, you have to have a certain level of capacity, a mental capacity to do those things. So you have to understand what the documents are, how they can be used, how they can be abused, or how your representative or attorneys can misuse their authority. But the one major one where we find is the most difficult for a lot of people, even if there's no mental health issues, some people still don't know this stuff. Is they need to be aware of their assets and their approximate value.
Right.
So, and this can be a issue where we have a lot of some couples where one party is dealing with all the finances, the other party's kind of, on the sidelines. Maybe they just trust their spouse to do everything. But that can create a real problem when the spouse that's managing all the finances passes away.
Right.
Now the remaining spouse comes in with their kids and like, okay, my mom needs this power of attorney. But dad used to do all the finances, so we need to help her with this stuff. I sit down with her and I say, okay, well, tell me a little bit about your finances. Okay, so do you own a property? How much is it worth? Where do you do your banking? How much money do you have in the bank? What types of accounts do you have? And a lot of people don't know this stuff because they just never dealt with it in their lifetime.
Yeah.
So the reason I mention that is just so important to make sure that, if you're the one in the family dealing with all the finances, make sure the other people know what's going on and how it works and where to find this stuff if they need to. You're not doing them any benefits by keeping them in the dark. You're not protecting them.
And I agree. I think it's especially prevalent with people of my generation, where it was usually the men that took care of those things.
Yeah, not always. A lot of times it's the almost half the time it was the wife that was looking after the finances, and the dad and it really has no idea what's going on, and it's just so sad because they're completely then dependent on their kids. And then not only that, but a lot of times they can't even meet the capacity requirements. I have to send them away and say, hey, look, I think you still know it. I don't think you got Alzheimer's or anything like that, but you need to know this stuff before I can do it for you. So why don't you review your finances and then maybe come back and see me, and then we'll try it again. Yeah, it's really interesting how often that happens.
Yeah, I've known a woman who didn't even know how to write a check on her own. She never did it,
Mm-hmm.
which is it's sad. Another thing I want to ask is, you can go online and get these little will kits or whatever.
Yeah.
Now, how good are they?
I think they have their value. Not everybody can afford to get a will professionally done. And if you got a very simple will that you want to do, or let's say you just want everything to go to your spouse and then equally to your kids, you might be able to get away with doing a will kit. I wouldn't use a will kit if there was any potentially contentious matters, like if you're leaving a child out or giving somebody a smaller share, anything that could result in like some challenges to the will. I wouldn't use the will kit for that. And with a will kit, you just have to just remember you're now fully responsible for making sure your will is properly executed. You need to get it properly witnessed, and if there's a mistake made, the will may not be may not be considered valid, and you may not be able to or your executors may not be able to probate it. So I think generally I would recommend getting a will professionally done. If I have to go on record, I recommend getting a will professionally done. However, I don't discount or the will kits. I think they do have some value.
I suppose if it's all really, really simple, no investments anywhere, just whatever you have it in your bank account, or would be not so bad, right? To do
yeah, that could work. Like I said, if you know exactly what you want, it's very simple. If it's maybe your family situation is quite simple. Also, if you got a blended family and you're like splitting things up between the two different families, or kids from the previous marriage, kids from the current marriage, again, that's that could get a little tricky. But I think for many people, if they have a very simple family situation and they have very simple wishes and it's all equal between the parties, there's nobody being favored or disinherited, then it may not be a bad way to go.
Okay, so here's a scenario. You're living in another province. You have a will there. They had a will made there, and you move to another province. Is that will still valid?
It might be still valid. I would definitely recommend getting it looked at by a lawyer or notary, generally speaking. So wills, the laws about wills in Canada are specific from province to province. Each province has their own legislation to deal with estates. So again, if I have to go on record, I recommend that if you go to a new province, you should get a new will done. Like if I have a client say they come in to see me and they say, you know what, we're moving to Ontario next month, I want to get a will done, I'll have no problem saying, hey, you know what, don't bother. Wait till you get there and get a new will done when you get there, because you may have to redo it anyways. So yeah, I would say it's best to get a will done in the province that you're living in to make sure that it meets the legal requirements of that province's estate legislation.
Yeah, I was just thinking about, you often, when you're reading for different things, it says except in Quebec. So I'm thinking, make sure that if you're moving from Quebec into another province or the other way around, that you have your will done. Definitely redo it. What about, again, if you had a will made, like say 20 years ago, should you update it? Well, maybe nothing's changed very much.
Yeah.
Still, should you update it?
So some people believe that a will should be updated every 5, 10, 15 years. I don't know how important that is if nothing has changed. Um, what I often see is that families will come in when the kids are young to do a will, and then they'll come back about 20 years later when the kids are now adults and they change their will. They want to take out the guardianship clause because the kids are now of age. They want to maybe now, instead of having their brother or their cousins as executors, now they want to have their children act as the executors. So that makes a lot of sense, about that 20-year gap. Some people I've coming back every couple of years to redo their will because they change their mind about who they want to give this to or who they want managing their affairs. But for most people, I would say they're coming back in 10-20 year intervals, I would say. But I think no, sorry, go ahead.
Yeah, go ahead.
Oh, I was just going to say that I don't think it's necessary to redo your will every 5-10 years, unless you want to change something, like especially the executorship. That's usually what people most often want to change.
Yeah, right. What was I going to ask? Oh, darn, it's gone out of my head. Say something. Well, I think about what the heck. I was going to ask that question. I can't remember it. Darn it. Oh, I know about cost. Is there like a cost per se of the basics of the will, and then that increases by how involved it is?
So one nice thing about using a notary is we don't charge an hourly rate. So we have a flat rate for a will.
Okay.
The only reason why it might cost a little bit more is if you are disinheriting a child or leaving a child a smaller share, basically something that could give rise to a what we call a wills variation claim, where one of the beneficiaries or jilted beneficiaries makes a claim against the estate. That can result in litigation where the notaries then has to go testify. So if you're doing something like that where you're doing an uneven distribution or giving somebody a deliberately smaller share, where they could come back and challenge the estate, we charge an extra $100 for what we call a WESA affidavit. It's basically an affidavit that we would prepare and get you to sign, just confirming that you've been advised that the child could contest the estate, but you still want your wishes to be followed. So that's the only extra cost that you could potentially expect. Other than that, it's a flat rate for our wills. We don't charge more based on how complex the will is or how complex your estate is. It's the same cost for everybody.
That's good to know. So, okay, so I have a will, I have an executor, which would be one of my kids. Yet the other one, like my son, for instance, lives in China. Does that make things more difficult?
Not if you're just naming him as a beneficiary, but for executorship, we certainly recommend that you appoint somebody in Canada, and even better if they're in BC. The reason is because if they live in a different jurisdiction, meaning outside of BC, there's some extra hoops to jump through as an executor, some extra requirements. They may have to post a bond equal to the value of the estate, and it gets just a little bit more tricky. Not impossible though. But if they live in a different country, that can create tax problems for acting as the executor. So I certainly don't recommend appointing someone that lives in a different country. Although again, it's possible. It's sometimes that's the only option people have. But if possible, your executor should be in Canada, and if possible, in BC.
Who takes care of probating a will?
The executor does.
Oh, okay. So they can do that like themselves. Like I know that from one of my sisters that you can go online and it's all the information is there.
Yeah. So if you are appointed as an executor, so the first decision you have to make is, are you going to probate this estate? And that comes down to your earlier question about the value of the asset. So if it's under 25 grand, maybe you can get away without probating. If it's over 25,000, or if there's property involved, you definitely have to go through probate. So that's the first question that you'll have to figure out. The second thing is you'll have to decide, if you do have to apply for probate, are you going to make the application yourself, or are you going to hire a lawyer to do the application for you? There's a bunch of paperwork that you have to do. You have to submit basically an application to the court when you want to apply to be the administrator or the executor of an estate. even if you're named in the will, you still have to go through this process. So for many people, they just don't have the savvy or the time to do these, to prepare these legal documents for the court. So if you decide you're going to do it yourself, there are kits that will help you through that. They're called probate kits, similar to the will kits. You can get them from Staples or on Amazon, and they'll walk you through the process and provide you with the paperwork you need. Alternatively, yes, you're correct that you can find that stuff online. I don't know about the guides, but you can certainly find all the forms you need online through the court registry website for BC, and it's pretty good. They have pretty much all the affidavits and stuff you need to prepare. Or alternatively, you can hire a lawyer and they're going to do all that work for you, and they will charge you either somewhere between $2,000 to $7,000, or they might charge based on the value percentage of the estate. It depends on how complex the estate is. If you hire a lawyer, how much they're going to charge you.
Right. Now, when my husband passed away, now I've forgotten some of the details, but I needed so many copies of a death certificate, and everybody wanted a copy of the original. Now, if you have an original, can you take it to a notary to have copies made?
Yes, absolutely. We call those certified copies. So a lot of people come to us for many types of certified copies, but especially when somebody passes away, they sometimes need certified copies of the death certificate. That's very common, or sometimes even certified copies of the will. One important thing to note is, just like you said, you must have the original to get a certified copy done. Don't show up here with a photocopy or another certified copy. You got to bring in the original, and then we can make you as many certified copies as you.
Right, because those are things people need to know ahead of time. I mean, it threw me because I didn't have enough at the beginning, and it's like, you're in a state of, well, it's a very upsetting time, right? And so it's hard to think properly. You need this. So it's good to know these things ahead of time, I would say, right?
Yeah, and one thing I like to mention is, we got a pretty open door here. A lot of people come in when somebody passes away because they just need someone to sit down with and kind of just talk them through the process and tell them a little bit about what might be coming, what they might be need to deal with in the future. Even though we don't do a state administration here, we can't do the taxes or anything. A lot of times we're the first place a person will go to when their spouse or child passes, or a parent, because they just need a little bit of guidance and just a nudge in the right direction. And we're always happy to do that. There's no charge for someone just to come in and sit with us for a few minutes and say, hey, this person just passed away. I don't know what to do. Can you just help point me in the right direction? We do that all the time for people.
That's nice to know. Yeah. So if somebody wanted to contact you, would they call Simpson and just ask for you, make an appointment for whatever it is they need?
Absolutely, yeah, for sure. And we have 7 notaries in total here. So if I'm not available, there's always going to be somebody here to help them. But I'd be always happy to help them out personally as well.
Right, and all they have to do is Google Simpson Chilliwack, Simpson Notary Chilliwack, and I'm sure everything's there that they need, right?
Yeah, they can call us at our phone number is 604-824-5500, or they can email info@simpsonnotaries.com, and all of that information is available online as well. So we can book appointments by email or by phone, or they can always, we get a lot of people just popping into, just walking in off the street, and if we're with a client, we'll just ask them to wait a few minutes, and then we usually can squeeze them in between clients and make sure they get seen.
Right. Well, thank you very much. This has been really, really helpful, I think, and I'm sure that when a lot of people, watch it, they'll also find it helpful. So I really appreciate you doing this with me, and hopefully you'll come back and when we need some more information.
Absolutely, anytime. I was happy to do it, and you had great questions, by the way. It sounded like, honestly, your questions made it sound like you've been through this before. I think you knew the right questions to ask.
Yeah, I had some help. I didn't know where to go, but at that time, there was my banking institute had a really wonderful investment counselor. He's not there anymore, but he made a list for me of what I needed or what I was going to need. And had I not had that, like I said, I would never thought of going to a notary for whatever reason, right? Because we don't know where to turn always, or who we should talk to about certain things. So it's good for people to know. And that's why I'm so pleased that you did this with me. So thanks a lot. Okay.
No problem. Before I let you go, I just want to say congratulations on the Cupcake Festival. I saw a really nice article in CTV News. So you made the big show. And Yeah, so congratulations on the success, and I can't wait to see what you do again next year.
Oh, yeah, we shall see. It should be a little bit different. This was our trial run, lots of things we learned not to do or to do better next go around. So anyway, stay on camera. Well, I just want to say goodbye to the audience and thank you for watching the show. I hope you found this as really informative as I did, even though, as Aatif said, Aatif said that I knew some of the question asked because I have been through it, but it's important to know where you can turn when you just need that guidance. So thanks again, everybody, for watching. Take care and peace out.
A sense of community, till the wax a place to be. A sense of community when you're free. Rolling through the mountains, rolling through the valley, rolling through paradise with me. It's multicultural, you're sure to see it all. Chilliwack's the place to be, you'll see. Come party in the park, go dancing after dark. Chilliwack's the place to be, you'll see.